Hello, everyone. Thank you. It's great to be here. My name is Mina Ilhan. I'm a second-year PhD student at the Law Faculty of Université Côte d'Azur, based in Nice, France. And my thesis is entitled Algorithm Disserving Justice. And I'm going to talk about risk assessment tools and pretrial process today. Before going into that, I just want to talk about a bit of my thesis. And so my main premise is that algorithmic decision-making is causing a paradigm shift in the norms of the criminal justice system. And I believe that a meaningful analysis of technical systems and law calls for a sustained work across disciplines. And I go on to three elements, and I talk about presumption of innocence, individualized sentencing, and evidentiary requirements. But today I'm just going to talk about presumption of innocence. So just for, as a way of introductory, what are risk assessment tools? And to go into that, we need to understand that risk is actually an old concept in law, and it's mainly used in insurance, tort, and contract law. And these tools, they predict the probability of future riskiness and dangerousness and reoffending, which we call as recidivism. And again, predicting recidivism dates back to the 20th century, so it's not something that has happened in recent. And these tools vary in their scope, design, and method of calculating and appraising risk. The way I see risk assessment tools is kind of in a four-circle kind of way. So I'm going to talk about bail, then a bit of conception of criminal justice, and obviously we need to talk about technology and situationalities, and also the concepts of risk and dangerousness. And following that, in order to situate it, I'm going to talk a bit about the criminal justice system in the peripheral countries, obviously. Risk-informed decisions did not appear with the prominence of artificial intelligence. Its proliferation began with the transformation of the criminal justice system in its quest of efficiency and efficacy. And in the 20th century, under the influence of legal positivists, espoused individual justice with a focus on rehabilitative treatment. But towards the end of the 20th century, we saw a lot of mass incarceration, followed the incapacitation theory, and we saw that it became the principal paradigm. Feely and Simon introduced this concept of new penology to denote the new punishment based on probabilities and risk. And under this new system, which is a type of an actual justice, have recrafted individuals and social phenomena as risk subjects, moving away from Enlightenment notions of individual justice. Due to time constraints in here, I'm just going to say that like quantifying and this actual justice goes way back, and quantification became incorporated into narrative form to know, assess, and judge legal subjects. Thus, what happened was an individual is datasized and fragmenting his, her, or their identity into different variables to denote different level of risks. And then how did this quantification actually reflect on criminal justice? So the actuarial risk management morphed into the dominant discourse sailing away from individual reformation. And we can see this in Jurek. So this is a capital punishment case, and it was affirmed based on future dangerousness. In this case, the jury was requested to consider whether there's a probability that the defendant would commit criminal acts of violence that would constitute a continuing threat to society. And the court said that a prediction of future criminal conduct is an essential element in many of the decisions rendered throughout our criminal justice system. And even though it is, of course, not easy to predict future behavior, the fact that such a determination is difficult, however, does not mean that it cannot be made. And there's another case, it's Bell and Wolfish. It's a constitutional challenge to the conditions of confinement in a detention center. And here the court held that pretrial detention, ensuring a defendant's appearance in court, is a legitimate regulatory function. So this case is important because the court betrayed the principle of presumption of innocence by defining its scope only as a doctrine that allocates the burden of proof in criminal trials that has no application to a determination of the rights of a pretrial detainee during confinement before his trial has even begun. Likewise, in Scholl and Martin, the court stated that there's nothing inherently unattainable about prediction of future criminal conduct. And it said that it is possible to predict future behavior. To sum up this section, these cases paved the way of inferring guilt and designating riskiness to pretrial detainees. It sets the stage for expanding pretrial detention based on other factors by holding that pretrial detention is not punishment if related to a legitimate governmental objective. It gave blessings to limiting the rights of the accused by predicting dangerousness or riskiness without determination of guilt, even when there's no risk of flight. Goal and his colleagues said that courts allow virtually any type of risk submission. So we're now coming kind of back to rats again. I'm gonna do that a couple of times. So why do we actually use rats? So it's been said that it reduces cost, it's efficient, it has a major role in the bail reform movement in the US. It's said to be neutral, it safeguards against arbitrariness, it combats against human bias and mass incarceration, and because it's believed to give consistent sentences. And so again, it's very connected to pretrial, obviously. And pretrial is actually a very ancient institution. It actually has its roots in Anglo-Saxon history and actually unites all the common law systems. And in essence, there lies a clash between due process rights and public safety. And a lot of human rights instruments states that pretrial detention should be an exception and it should never be used as a form of punishment. Because we do not live in a suspect society and we do not believe in creating criminals out of individuals. And to briefly talk about bail, it is a cash or bond property. So it's a security given by the accused that he will appear before the court at a later date. And it's actually a fundamental right. And now again, coming back to rats. How do rats work? So they're basically statistical models that compares and measures individual characteristics against the historic data. They're made up of static and dynamic factors. And then there's a checklist of risk factors and data to statistically correlate with risk, which includes non-appearance or commission of new crime. Then the output that the algorithm gives is a risk score. Then these scores are turned into a generalized risk category. So there's a spectrum where it's like low, moderate, or high. Then these are read in tandem with decision-making framework or matrix. And just to remind again, these tools are not uniform. Opa. I don't think I have much time, I'm assuming. So I'm gonna kind of, so just to say static factors, they do not change, they're historical factors. And dynamic factors, they require interviews all the time because they're pertain to mental health. And just to note that most of the risk variables, they are based on socioeconomic factors, which in the last analysis kind of actually punishes class or punishes poverty, for instance. And just again to note that correlations of these tools are not causations. Rats solely turn correlative insights into casual scoring mechanisms, and they're not designed to address causations. Why can't I do that? So as a way of example, these are the different types of risk assessment tools, and these are the different types of factors that are taken into account. As you can see, it's not uniform. And to briefly talk about Compass, which is a very widely used risk assessment tool in the US, it's proprietary, it's based on dynamic interviews, and there's around 137 questions, and it measures flight risk and recidivism risk. So it includes like family, education, mental health. And this is an example of a questionnaire page. So it asks you whether you use drugs or not, whether you live alone or not. And I'm going to come back to this when I'm talking about the case law. So I'm skipping this as well. And there's another very widely used one, and the public safety assessment, it's public. So we know how it works, and it's based on static factors, and it measures three outcomes. So flight risk, new criminal activity, and new violent criminal activity. And again, I'm timekeeping. I'm so sorry. I'll try to address the questions around it if there are any questions. So these are the 9 input features that are fed. So as you can see, like 4 features for failure to appear outcome, and then there's 7 features in one and the 5 features in the other. And then these are read in tandem with the release condition matrix. And one important thing about these release matrix is that this matrix is the one that recommends action. So whether you're going to be released or whether you're going to be released pertaining certain conditions, because it's the release matrix that is used to manage risk. The PCA risk score is just used to measure risk. So recommendations are not decided by the algorithm, but by policymakers. And in here, just again, as a word of reminder, I suppose that utilizing rats emanates the possibility of engaging in future criminal conduct to shape the fate of an accused in a criminal process. And it's kind of interesting to note that, like in California, judges use rats to support setting bail, but they often regard the tools when they recommend release. And I think this is kind of used due to the fact that judges are known to be risk averse. So coming to our case law. So we have the most important one is Loomis, which a guy was sentenced to 6 years in prison sentence due to the Compass risk assessment tool. And the sentencing judge told Loomis in this particular case that in all of the different types of recidivism measured, he scored very highly. And so he had a very high risk to reoffend. Then Loomis challenged his sentence on due process grounds, arguing that the judge's use of the Compass score violated his constitutional right to a fair trial. And the Supreme Court, in the end, held that the trial court's use of Compass in sentencing Loomis did not violate his due process rights. And even though the algorithm is proprietary and the way the assessment was made was not disclosed to the court, because Compass did not appear to be the sole basis for the trial judge's sentence. There's another case law, and it's Rosen State. In here, the Court of Appeals considered another risk assessment tool application in sentencing. And the court said that it's an abuse of discretion to rely on scoring models to determine a sentence. And it actually undercuts the trial court's responsibility to craft an appropriate individualized sentence. In Malanchik, the Supreme Court referenced Rhodes and did not agree with it. And it held that the results of such testing, like the scoring algorithms, can enhance a trial judge's individual evaluation, and that they actually trust the discretion and discernment of trial judges to give the tools proper consideration and appropriate weight. And in Younglove, again, it was a constant appeal challenging Compass. And the Supreme Court again said that it does not pose any threat to due process rights. So as we can see, we have very different views on rights, whether it's a good practice or not. But one thing is kind of clear is that, like, despite the statements of courts, except in Rose and Everett is a Canadian case that I did not talk about, Barabbas and his colleagues argue that risk assessments have evolved from a tool used solely for prediction to one that is diagnostic at its core, rather than aiding sentencing decisions. So in here, there almost seems to be a consensus that these tools are not used conclusively in the decision-making, that it is not a vital component of sentencing. And so there's kind of a denial about the true impact on utilization of rats, because if a tool has no impact on sentencing, then why are we using it to begin with? And before going to sketch of my issues and to my kind of findings / preponderance, just to remind us that the underlying problems in these tools are not limited to the scene of algorithms. So most of the issues and problems we face are already present in our criminal justice systems. And also, we must read these tools within the following structure. The existing legal and regulatory frameworks and norms that we have are designed for human decision makers. So, Holmes says that the life of law has not been logic, it has been experience. And as of now, we can say that the experience we have with rats kind of points out to calculating justice on people. However, tracing the experience of the criminal justice system with regards to these tools has been really challenging, as there's no uniform application, there's insufficient amount of case law, and there's another issue is the differing results of mainly computer scientists and the findings that they have found when analyzing the same tool. And I think as jurists, for us, it is very difficult for us to determine the veracity of these technological tools. But we can kind of say that there's indeed a disruption, as the Loomis case kind of points out. Trade secrets has been given privilege in a criminal trial, and the right to fair trial is at crisis. So we can definitely say that. And we can also kind of admit that law is political and the techniques are never neutral. So from gathering data to logging the data to coding. And in the last analysis, algorithmic decision makings ultimately are based on assumptions. For example, the quality of the training data or the actual modeling relations employed. As such, it does not matter how complicated the algorithm may be. It will always represent one specific vision of the system being modeled. Koch and Robinson state that in the long term, these tools risk giving an imprimatur of scientific objectivity to ill-defined concepts of dangerousness. It may entrench the Supreme Court's historically recent blessing of preventive detention for dangerousness and could pave the way for an increase in preventive detention. And the paradigm shift that I'm referring to, that I'm trying to purport, is an exploration and a statement at the same time. It's a statement as technology shapes our practices and beliefs. As Verbeek puts, he says that technology mediates human relationships with reality, and it shapes the way in which humans relate to the world and the relationship between humans. The fact literature's emphasis on, for instance, humanizing AM, for me, partly seems to stem from the mind as computer metaphors. This concept is explicated by Gigerenzer and Goldstein with the tool to theories heuristic. And it is the notion that partially theories emerge from the tools that are utilized. For example, they provide an example of mechanical clock, and they argue that how its invention has rendered the physiological processes in mechanical terms. So they observe that the usage of statistical analysis tools perceive the human mind within the following frame of reference. The tools become a theory of mind. Similarly, in the 1960s, in the quest of building a machine that works like a human mind, a computational theory of mind was purported, which led to the cognitive scientists to depict human mind as mimicking computational processes. And the exploration side of it, so from the statement comes the exploration side of it. So as we know, norms can be open or closed. And the legal norms are closed, whereas technological norms are open. And the peculiarity of these tools in criminal law is the interplay between the worldwide acceptance of the technical norms and the endeavor to legally rein technology. And the failure to administer the reins creates a permissionless space feeding into the popular discourse of technological determinism. And the space kind of reflects the reflexes of capitalism and privileges the potential for benefit over the risk of harm, threatening to derail more democratic approaches. So as we said, technology does indeed shape the discourses and belief, but albeit not autonomously. Technological determinism is a political and normative choice, as well as a stance that technological companies take. This relates back to the paradigm shift in the way determinism offers the inevitable discourse. Rats are a natural extension of the old risk assessment methods, but this conception negates the deliberate usage of these tools in the criminal justice system. But on the other hand, there is a conscious and unconscious embodiment of values to technical systems and artifacts. And the tension between value-free tools and value-embedded tools is ultimately a question of which normative discourse we stand to take. And again, due to the fact literature, there's an appropriation of fact values, and ultimately the values that we embed is stemmed from our relation to technology. Those, again, which conception of technology one adheres to is quite vital. And the value in this context of the tools and criminal justice system is very, very crucial, is because the seriousness of the subject matter of criminal law, and especially the values embedded in tools have long-term implications that surpass their designers and builders. How am I doing on time, by the way? Good, bad?
You have 10 seconds.
Oh, no. 10 seconds. Okay, not gonna happen.
If you could address the conclusion, I think.
Okay, I will try to. I mean, I did not presumption of innocence. How can I? Okay, let me try to address the conclusion. I was going to talk about presumption of innocence, but maybe I can just say that with the topic of presumption of innocence, there's a huge interplay between the tension and ethics of punishing the innocent and failing to convict the guilty. And we really need to think about how to operationalize legal concept of presumption of innocence and human behavior into specific measures that enable the building and evaluation of these systems. And I'm so sorry, I'm out of time. So yeah, I think I'll just say thank you. And I'm sorry that I went over time.
Thank you very much, Ms. Ilhan. Now we have one question sent by the audience.
Okay.
Is there another? What?
Oh, sorry. If it's in the chat, I can't see. I have to stop sharing. Should I do that? Or?
Okay, you can stop sharing. That's no worries.
Perfect.
Okay, so I'll send you also in the chat. But the question is there another tool that you didn't consider in your paper and you recommended as an evolution of the research?
If there's a tool I did not recommend. You are sending the question, right? Yeah.
I have already sent it.
Oh, I can't see it. I'm so sorry. I thought, okay, I cannot see it though.
Is there another tool that you didn't consider in your paper and you recommended as an evolution of the research?
I didn't consider in your paper. I mean, I did not look at all the tools because there's more than I think like 12 tools. So I'm taking probably because I'm still in the in the next year, I'm still going to go more into ethnographic research, but I'm mainly using the two ones, but more or less, I don't want to be like too generalizing, but they hold the same principles. But the reason I chose Compass and the PCA as two contrasting examples, that the Compass was proprietary and has been, even though the Supreme Court accepted it, it has been quite criticized in all arenas by NGOs and whatnot. So public safety assessment tool is a kind of like alternative to it because it's more opaque, it's more explainable. And so maybe that's how I can answer your question. I hope that's a good way to do it.